our opinion within our state.
The ruling, your opinion, Your Honor, you said the issue of comparing, in effect of the opinion is that the fact that there is no law to actually compare, and that's what he said. Other members to extend sections to form the memo or a quorum for decision or section. The law provides that the speaker, the legitimate speaker, with the members he has, will continue to convene from time to time in order to encourage the other members of the majority back to come to power, to come to section. There is nowhere that the Supreme Court is in agreement. There is a constitutional crisis that is stated. Yes or no?
The ruling on this one came from a petition to declare the constitutionality of the act. And that ruling said, look, you minority, if we proceed without a quorum,
That's correct.
What specific money or instruction that you put in, that's all I know.
Thank you, Your Honor. That specific mandate is enshrined with Article 33 and 49.
But this people that come here, our instruction is one of our division.
They are being overrun.
In this ruling, we declare this right, you don't have the right, you don't have the wrong.
Yeah.
So what order do we get below that was about that?
The order you gave below is you said, in effect, in substance, you are saying none of these groups, the speaker black, the majority black, can conduct business in violation of Article 33 and Article 49.
All right.
Now,
so if that is that interpretation,
yes, sir.
if either party go and conduct business in the way we say should that be,
Yes.
is that also a fair information?
Of course, Your Honor.
No.
Because,
Councilor,
yes, Your Honor.
I tell you that if you eat over you will reload, there's something wrong. You if you eat over you will reload, there's something wrong. So you see me eating over you will reload, you come back to all you go to.
That acknowledge your sample with the fact sheet, Your Honor.
No.
Your Honor,
I think for no fighting over the use of the road. Then you come before you put it. But the road, anybody who is going the opposite direction is being you see the road. So you see the one going the opposite direction. You come back to the point where you traffic go.
your duty as a party in that case, based on the standards that you have set as the Honorable Supreme Court developed information, is to come back to the Supreme Court by the standard that you set based on your ruling. This party is proceeding in a way that infringes on your rights and undermines and impedes the integrity of the court. How did they impede the integrity of the court or undermine the ruling? One.
Why would they want a declaration of the law?
Yes, Your Honor.
In one man, don't read the good opinion. You want to put it for me? This court's interpretation of Article 33 of the Constitution is that whether a single majority is sitting or a low number in both cases, the presiding officer defined in Article 49 of the Constitution is the speaker. And in his or acting is the deputy speaker. Are you there? Where the speaker is presiding over a minority, the Constitution is void of the mechanism or how the minority is to compare the attendance of active members. And the legislature has promulgated no deliberate statute or standing rules setting forth the process for comparing absentee members to attend session as envisioned under Article 33 of the Constitution. And under these circumstances, the Supreme Court cannot do for the legislature what it will be its purview to do, and to do so will be a violation of the constitutional mandate on the separation of powers. Wherefore, in view of the foregoing, any sitting or action by members of the legislature not in conformity with the intent of Article 33 of the Constitution is out of violence. Hence, members of the House of Representatives are to conduct themselves accordingly. The clerk of this court is hereby ordered to inform the parties and it is hereby to order. Remember my question. Where is the order that will give the law that will violate it?
You just stated the order. The order is when you go back as members of the House of Representatives and you don't conform yourself to Article 33 and Article 49, your actions are unconstitutional.
Your actions are unconstitutional, right?
Yes.
So you come back to interpret.
We come back for you, Your Honor, because of the opinion that you gave, it has been disrespected. In effect, Your Honor, in effect, when you said,
Mr. Clerk,
you have to say,
on this court is hereby ordered to inform the parties. That's what I'm saying.
Your Honor, allow me to proceed this way. The basis, I don't know, I stand to be corrected, upon which the question is being filed, is being posed, it supposes to me that it has nothing to do with the constitutional crisis out there. But if this court is the constitutional court, and that the nation and the world is looking up to it to interpret and say what the law is by reinforcing or reinterpreting, let's say, enforcing this opinion of December 6, 2024, this court has jurisdiction. And that jurisdiction is a constitutional provision that you have declared and pronounced have been violated by the respondents. Yes, sir.
You know, when we come and start bringing infusing all of these sentiments into a legal question and the law, to be specific, it doesn't move this court at all. We read the Office of a Bill of Information and said the applicable provision of the rules of the Supreme Court is that to prevent anyone whosoever from interfering with the judgment and or mandate of the Supreme Court. You more or less said that this court made a declaration that if you're on this side, this is how we see you. If you're on this side, this is how we see you. That's why I asked, what about you? Because you have a role to play there, to go and ensure the promulgation of a law. Without doing that, you come now and say someone is interfering. How? Then I'm at a loss here, because where is the interference? Even from both sides, where is the interference in the first declaration? Where is that interference?
If the English is formal,
don't you think you just haven't done anything?
No.
If the one said that it lies with you, the House of Representatives, but
right.
This is what the law says. The Bill of Information, is this the office of the Bill of Information?
This is the
because the whole world looking at us to say what Arthur Johnson wants us to say, the whole world looking at us to say what the layman wants to hear us say. Did we not state the law clearly and give you all a declaration as to the law and say it is in the purview? We cannot dictate in the absence of a law because it will be what? Interference in another branch of government. Then you come here and say this court has jurisdiction. We know the jurisdiction of this court, and we apply our jurisdiction to say what the law is. Now you come up with information. It's specific. This is one rule of the Supreme Court that is specific as to the office of the Bill of Information. You say the applicable section is B, interference. So what is the interference? Not what the whole world wants to say. Answer that question.
Then
we're going somewhere.
So the interference of your ruling law is when the that you must be constitutionally sitting as a competent authority before you can perform legislative functions in keeping with 33 or 49 of the Constitution. They went further.
That's what according to your argument.
You know, you can ask a question. I will let
This is our court. That's what according to your argument there, that the other side or the other party are doing X, Y, Z. Okay, they are sitting, they are doing this, they are doing that. It comes there again. Where is the law with us subjecting this court to interfering in the other branch of government? What gives the authorizes the court to tell them do not sit, do not do nothing, do not do anything? Where is that authority in the absence of how we can get that group to come on the other side? Where is that authority?
First of all, the authority is in the Constitution. The Supreme Court is the final arbiter on constitutional issues. The interpretation, the clear interpretation of issues on constitutional matters brought before the bench of the Supreme Court will follow D and D as
What was the issue brought?
The issue brought was the respondents accorded unto them an authority that was not described to them by the Constitution.
And what did we say?
You said that if you sit as a body and you do not conform to the Constitution, you are ultra bound.
And on the other side, what did we say?
We also said that they are legitimate.
No, we never said that.
Unless you said that the
Counselor, this one did not say that. Read from the opinion what the court said.
No. In effect, if the Supreme
Counselor,
Court, yes,
if we can't concede, we can't move forward. We never use the word legitimate for.
no, I just said it's not that we expressed it, stated
No,
it
but I
as it
didn't
was.
say it.
But when you said that the speaker, the presiding officer of the House
Counselor,
of
please
Representatives,
read it from the opinion. Read it from the opinion. Yes.
the opinion that you better state that the informant is the legitimate speaker. He didn't say that. But this one also recognizes that the legitimate speaker of the House of Representatives is the informant, co-informant, Councillor Onati Koffa. Unless the Supreme Court says that the opinion that they gave on December 6th did not recognize the informant Honorable Koffa as the Speaker of the House of Representatives.
Councilor Johnson,
Yes, sir.
taking you back to the definition of the office of the bill of information. According to your reading, the bill of information has legal rule to fulfill.
Yes, sir.
One is to prevent the judge
Yes.
or the judicial officer from attempting to execute the mandate of the Supreme Court. Or from interfering with the execution of the mandate of the Supreme Court.
Yeah.
That's the first one. The second one, which you say is the basis of your bill of information, is that the bill of information will also lie to prevent any whatsoever from interfering with the judgment and or mandate of the Supreme Court. And I think this is where the question is coming from. We are having very, very responsive. On the other hand, the first thing that we want to know is what was the mandate text. At least, what was that mandate? What did the Supreme Court see in that mandate? First, when we get that, when we get what the Supreme Court said in that mandate, then the second thing that we want from the is we will demonstrate to us how that mandate was, I want to be very specific, yeah. Yeah, how was it interfered with? Who interfered with you? So that's the very question. That gave us the mandate. Well, yes, the council in agreement with the Supreme Court, that is specific. What was the mandate? What did the Supreme Court say that was supposed to be executed, that was supposed to be obeyed, that was supposed to be followed, that was supposed to be adopted? What did the Supreme Court say? When you gave us that first, then you go to the second point now. How was that interfered with? That's the second one. And by whom? And how? So when you get it to us that way, then we'll be able now to make a sense. Well, when that happens.
Thank you, Justice Koffa.
So first, what is the mandate?
The mandate of the Supreme Court.
Counselor, there's sometimes when you are pleading, you don't plead in a way to present all the information and get yourself choked. In my own opinion, you are saying you are finding a bit of information based upon the interference with the post mandate. That mandate itself should have been part of your pleadings. That mandate should have been before us, so that when we look at it, we know exactly what we are saying. But currently, you don't have to mandate them with you. This is the mandate on what the Supreme Court said. The Koffa ruled that any legislative actions. No, Council, that's the mandate of the court is still in the same economy. And when you see the Koffa rule, they tell you that you have really the mandate to do
that. First, these are the things we capture in your amendment. That the members of the House of Representatives will go and conduct themselves in line with Article 33 and 49 of the Constitution. And that any sitting that is carried out.
I don't think the best thing we can do is maybe you let someone opening, get yourself prepared, and the other party give us something, let's hear from them, because you still not giving us the information that we desire. The information we desire is you say somebody interfere with the mandate. Tell us what our mandate is. You don't know the mandate. You are trying to fence around all kinds of things, So you don't know the mandate.
I know the mandate, that's what I'm saying. I don't have the mandate here, but I read the mandate. Remember the answer.
How would you convince us now that we're coming there on our if it was part of your feeling, it would be reading it. It's not there. It's not there. There's nowhere to be found. Nowhere here that is any of the Supreme Court. And you say it was about there, interfere with. And where is it?
The mandate was, Your Honor, that members of the House of Representatives are to conduct themselves accordingly.
According to what?
According to Article 43, 33, and 49 of the Constitution.
According to yourself, in the line of opinion that the Supreme Court interpreted what hypothetically, how hypothetically Article 49 can be applied. So if you get the mandate, if you had the mandate with you, then that mandate would have come up clearly and tell us, one, the Supreme Court said this, two, the Supreme Court said this, three, the Supreme Court said this. When you come up with those points now, then you come to the second argument, how was that interfered? How was that out there? Then what went contrary to, that's the way an argument should come. But what you're telling us now is you just making a lot of assumption trying to put things together that are there. That's our problem. The mandate should have been with you so that when you're talking about the mandate, you're looking at the mandate and you convince us about it. That's how people argue.
So, Councilor, you want to yield on the opening so you can come back to close? So let's hear from the respondent.
Okay, we close on the opening.
Thank you. Respondent, you may proceed.
debate with the audience. In your judgment of December 6th, 2024, you said, having carefully examined the contentions of the parties, listen to the arguments on both sides, and consider the laws relevant there to Louisiana and Georgia, that the Supreme Court, pursuant to Article 66 of the Constitution, quote, shall be the final arbiter of constitutional issues and shall exercise final appellate jurisdiction in all cases, whether emanating from the Court of Record, Court of Record, administrative agencies, autonomous agencies, or any authority, both as to law and to fact. Hence, the Supreme Court has the jurisdiction to decide constitutional issues arising out of internal dissensions among the members of the legislature, as in the present case. That it is the law involved that the Constitution must be interpreted in light of the entire document, whether there is a personal pronouncement, because every provision is of equal importance. And even where there is apparent discrepancy between different provisions, the court should harmonize them if possible. That this post-interpretation of Article 33 of the Constitution 1986 is that whether a simple majority is sitting or a lower number, in both cases the presiding officer, defining Article 49 of the Constitution, is the Speaker, and in his or her absence, the Deputy Speaker. That in the event where the Speaker is presiding over the minority, the Constitution is devoid of the mechanism for how the minority is to compel the attendance of absent members. And the legislature has promulgated no enabling statute or standing rules setting forth the process on compelling absentee members to attend sessions as a provision under Article 33 of the Constitution. And that under these circumstances, the Supreme Court cannot do for the legislature what is within its purview to do, as to do so will be a violation of the constitutional mandate of the separation of powers. Wherefore, and in view of the foregoing, any sittings or actions by members of the legislature not in conformity with the intent of Article 33 and 49 of the Constitution are authorized. This is what you can talk. Now, informants have not one moment said that there was a convening of the House of Representatives with all these simple majority. Nowhere in another commission. That's I could agree on the Constitution. And maybe for me, I won't say for you, because the court is going to do the law. For me, here's what it says. A simple majority of each House shall constitute a quorum for the transaction of business. Nowhere in another commission has it said, our respondents sat, they were elected and said, nowhere. They have not proffered any little information is alleging facts. Facts to cause your own to say, you have violated our judgment, you have violated our mandate, or you have departed from our mandate or from our judgment. That's all.
Please clarify this one. You said nowhere has the informant formed this court, but our evidence that they had a sitting in which the asked other people to join the other people refused. Is that what I get?
No, I said, nowhere did they say that when the respondent sat, presided over by the Deputy Speaker, that they didn't have the simple majority requirement of the Constitution. That's what I said.
Well, he said the majority said with the Deputy Speaker.
Presided.
Was the Speaker here instead?
Yes, Your Honor.
I'm talking about the informant, jail people.
Yes, Your Honor.
And certain members of the House of Representatives.
Yes, Your Honor.
They were part of that sitting.
No. He chose not to vote.
Is there
president pro tempore presides. So when the majority are seated inside, you, the speaker, will go there and preside. If you are not there, and the deputy speaker is there, the deputy speaker has an obligation to what? Preside in the absence of the speaker. Just like the president pro tempore normally presides in the absence of the president of the Senate. That's the Chairman. That's the Chairman. When he's present at the meeting, nobody has care. So when the vice president called a meeting of the Senate, can another group of people go and call another meeting in another area to say that when you come and sit here, we are going to have a separate meeting? Is that your argument? No, Your Honor. Okay, my argument, let's bring that to the situation we are in now. Here is the speaker sitting in the speaker where the house normally meets. It may not be a particular place where they normally meet. The speaker is there. He called the members of the house to come and let's meet in this place that normally meets. Come, let's meet and then discuss this matter. Come, let's meet and do a session, to have our session. Then some group of members refuse to go and sit in that area and then go and invite, open another area and say, well, we are going to meet in this place here. Then, of course, we inviting you to leave from there and come to us. You come to us and let's sit here. I'm the presider, I'm the speaker. I was elected by you to preside over the matter. I called the meeting and I called the section, but then you said, no, you are having a matter section. The deputy speaker will be here, he will be presiding here, all of them come to us here. And so I'm asking you a question. Is that what is contemplated by the Constitution? No, Your Honor, but let me explain. Let me explain. It is the majority that elected the speaker. When we came here first, we came on what? A petition for a real commission. And we exhibited the institutional justice. There is a complaint against the speaker's access levels.
see going on there is the House of Representatives is trying to decide how to address or manage this conflict. And I believe on that basis, Cuba Johnson having recognized the constitutional authority of the House to remove the speaker inside and not issue the review. And the party for that. It should also be recalled that place you call the regular chamber is a chamber with those to which you are close by Marco and others. And saying, you, the majority, do not go to the before. Which all the majority go to the joint chambers.
Councillor Sherman, those facts are not and will never be before the court. Those facts are not and will never before this court. So I will stop you right there from bringing it out. Now, the present respondent, the present respondent, let me properly designate them and found the Honorable Richard Cole, Speaker of the House of Representatives, and other members of the House of Representatives. In their brief, that's how they designated themselves. In the other people's brief, it was in the informant petition, and we asked their Speaker, Koffa. Koffa as the Speaker. Now, albeit this is a bill of information, this court will never forget that. But as you so meticulously read and provisions or sections of our ruling of December 16, 2024, let me refer you to page 21 of that ruling, starting from the second paragraph. The respondents for their part, that is Honorable Kuhn and others, for their part have counter-argued that they have already expressed a vote of no confidence in the leadership of the Speaker, that their quorum in the joint chambers of the legislature is legitimate for the transaction of businesses in next the constitutional requirement of a simple majority as prescribed in the Constitution and the rules, that their quorum is being chaired by a presiding officer in person of the Deputy Speaker, who is legally clothed with the same authority as the Speaker to preside over their deliberations in the absence of the Speaker, that they have cited the petitioners and other minority members of the House to attend session in the joint chambers, but they refused, and that they are constitutionally vested with the authority to conduct the business of the House of Representatives. And we said that, like the petitioners in this case here now, the informants, the respondents have also drawn our attention to the constitutional phrase, quote, a simple majority of each house shall constitute a quorum for the transaction of business. We went further to say there that, look, when they said about the issue of a vote of no confidence raised in their returns, this court has opined in the case Parkwood versus Jalal et al. Supreme Court opinion October 3rd, 2014, that, and I quote, the Constitution provides the framework within which the legislature operates, and any act, including a vote of no confidence that breaches constitutional provisions or due process shall be subject to the judicial review. So we said that both parties had relied upon Article 33. And coming to page 33, in interpreting Article 33 of the Constitution, this court says unequivocally that whether a single majority is sitting or lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in his or her absence, the Deputy Speaker. This is the court saying what the law is. Now, that story you are explaining and whatnot, we found certain aspect of it in the returns, in the original case that is now under review, that your clients have said, no, you did a thing of no confidence. Or we said that, look, this is the law, because they said that because we have a greater number, and we have this presiding officer, the deputy speaker presiding, and they didn't say where the speaker was or anything, and we called the minority to come over to us. So we said, look, both of you have depended or relied upon Article 33, and this is how we interpreted Article 33. In interpreting Article 33, this book says unequivocally that whether a simple majority is sitting or lower number, in both cases, a presiding officer defined in Article 49 of the Constitution is the Speaker, and in his or her absence, the Deputy Speaker. This is the law. So if we want to infuse anything in it, we say, look, both parties, this is what the law says. Now go and govern yourself accordingly within the context. Then you come and say that somebody went no special place, right there, no special place. But we said this is the law, and go and govern yourself accordingly. If there is a speaker that is provided for under the Constitution, he or she is and remains the presiding officer for the transaction of business. So in essence, where these people coming from, you say they voted and this and that, how did that take place?
Your Honor, the House of Representatives, and when I say the House of Representatives, majority of them, before they themselves conceded that what they call the majority bloc was initially 43 members of the House. It's in the meetings.
Yeah, we have attached a listing there, and we say we're not going to even look at that listing because this court cannot take in evidence to call those signatories and names for them to appear here and to answer to their names. We're not even going to look at it, and we did not look at it. But we say this is the law, and vote and govern yourself accordingly. So why was the presiding officer, okay, and present? Because I don't see how it comes to the Constitution here that you will be sitting somewhere and call the minority or the minority under the Constitution is being headed at that time by the presiding officer designated or named by the Constitution as the Speaker.
Your Honor, I don't think your interpretation also create a paralysis, a dysfunction in the House of Representatives.
No,
No, that was not your intention. That wasn't your intention at all.
I agree with
You
you.
said, you the minority, the Constitution provides that you can compare the attendance of the minority, but there is no mechanism for it. And we, the court, cannot provide an mechanism for you. How else would the court operate without the minority?
Notwithstanding, as I read the full text there on pages 31 and 33, we said that, look, as you practice it, we don't want to paralyze the House of Representatives because the law is clear. If you're not sitting, if you're not doing anything, the other component, the Senate, can do nothing also until you're sitting legally, both of you. That's the law. Okay? And we said here, look, Article 33 was the focus vis-a-vis 49 of both parties issue, was an issue by both parties. So we said, look, yes, we see you with your numbers, but this is the law as regards Article 33. You who in the minority, okay, the presiding officer, now designated as the speaker, you are in the minority, but the law empowers you or gave you the authority to compel absent members to come, not majority. You say where you like a quorum, you can compel absent members to come to form a quorum, not majority. Now you're telling us that this quote-unquote majority, okay, try to call the speaker, which is ultra-virus, to come to a meeting on the other side. And we have said it clearly in the interpretation of Article 33 that, yes, the only thing wrong here, there is a speaker, you are the speaker, but you are in the minority. To compel, you don't have the law. So does that, with your argument, does that give the right to those absent members to go and form themselves into a majority bloc?
You don't form yourself into a majority bloc. You are a majority bloc because you are 43. And now the one increased up to more than 50. And at that, and each of them begin.
That's why you have to increase to 100. We are saying, we said, and we will say again, we will say it again, you can be 1,000. But we say at the time of that petition, we were clear, we say in the instant case, the legislature not having given an enabling statute to ensure compliance with Article 33. At that time, there was a presiding officer, there was a speaker, okay, that will cause the court, to do this. So the court cannot do for the legislature what they should do for themselves. This is what we said. So what made you go now and designate another speaker when there was already a designated speaker when this court spoke?
It was not a designated speaker as such in all cases. Let's go back to your own statement of facts.
Yeah.
Let's assume they have all had it. And when the speaker was never able to get why did 43 even though
when we need their rules, their regulations, and we don't just put them together because we feel like working on all these rules and regulations for this very reason. So that when there's a crisis, there's something we can refer to. Let's take the Supreme Court, for example. We meet here in this people. Then all of a sudden we have a problem. And we know that one time on the 6th floor, when we had a COVID floor, my CJ can come up here to us. Other than that, we are going to proceed without you. You understand what I'm saying? So we have rules here, procedures for opening a court, we're supposed to open the court, we're supposed to do that. And you see, the problem we have if we don't follow those rules and procedures is that precedence for other groups. Because if this group in the majority can say, regardless of the groups, we are going to somewhere else form ourselves, and we are the majority, we are going to run the House of Representatives, then we ask them, so what are we doing? Yes, the Supreme Court has happened before, forget the rules. Let's proceed. And let's go and open our Supreme Court on the 6th floor. And call her to come and join us. If you just say, come, that's it. You'll take me, make me the Chief Justice, and we'll go. Let's go. I am saying that's why these rules are very important for us to follow so we don't have this kind of crisis. It's true, we don't have anything to do with who the speaker is or how they elect him, how they decide that he should, leave or all that law. We don't have anything to do with it, but you have rules. You have rules, and that's what they say. And the rules, looking at the Constitution, clearly says you got the right to choose the speaker, to elect him, and to remove him. Finish. That is what we are seeing here. But you cannot say, because we need the majority today or tomorrow, instead of following the rules and say, I need to remove you and continue. So you come back. And you decide, you can do whatever. Or you decide that you're going to take the majority elsewhere and proceed with another house. My issue for me, and my issue here is because we like to follow the Constitution, the rules, the guidelines that we have set for institutions. And that's how we get this country properly. If we don't follow it, we always have the situation that the country. So, let's say to you because of how in face of all the rules and procedures we have, that we still have another group operating and take into account the Constitution, operating when the speaker is present. When they have not, according to their own rules and procedure, properly remove the speaker. Remove the speaker from office. If they have not done that according to the rules, how can we get the speaker?
Your Honor, let me first leave our system. I think it may have a lot to do with our system. When the leader of the parliament loses the confidence of the majority, you resign. That's not wrong. When you lose the confidence of the majority, you resign. Because you are not able to conduct parliament with all support of the majority. When you lose the confidence of the majority, be the leader of parliament. Because when you are the majority, you cannot conduct parliament. If you tell them today, go back. And let's pick up Koffa resign for you. And they said, no, we are the majority. You have created a dysfunction. And they said, no, we are the majority. We have a deputy speaker, which by the Constitution says can act in the absence of the speaker. You created a dysfunction. You created a dysfunction. I said, if you were to look at it, I'm not saying that you would. You created a dysfunction in the governance of the country.
The argument is very sound when it comes to trying to maintain continuity. But the problem that we are having is the law. It is the law that we are having the problem. Acting within the confines of the law. But let me give you a scenario. Suppose tomorrow the 38 members of the House meeting against the level. We don't want to sit under the speaker. Another 38 members. That's a simple majority. Then the speaker now lacks the majority to preside. 38 members meet. They say, you know what? We don't want that speaker. So we're not going to preside over, we're not going to go and sit on it. We're going to put in our own chambers, we'll have our own sections, and whatever. It will be a good scenario for our system. In a parliamentary system, the law is built in a way that that vote of no confidence automatically takes out the prime minister. That vote of no confidence takes out the prime minister. But in our system, they said a 49-member vote is the one that will take out the speaker. So I don't see what is wrong with the majority that is about 50 now. Going there, say, okay, speaker, all the section, they call the section, say, okay, we have the petition, here's our petition, we don't think that we draw our they say, oh, we want to remove you. Then they want to remove you from ACPC, and after that, let's have a vote. So step aside, in the chambers, and then the speaker refuse to step aside, then the majority got a case. You see, they got a case there. Step aside and you refuse to step aside, the law is making you step aside. Then the law is making you step aside. But when he is still sitting, he's there, you have not removed him, then you open a parallel section. You know, a parallel section. You see what is happening? That creates chaos. That creates chaos. There is nothing that prevents the majority from going in where the speaker is and then raising the issues before the speaker has to get out.
And suppose he seizes it.
I will listen to
Oh, there's a rule of that. There's a rule. There's a rule in the House of Representatives that the presiding officer can seize and action on the agenda. There's a rule. There's a rule. So if you bring anything against the speaker who is presiding, he can seize it. There's no rule. Your Honor, I brought a rule. You want to go through it? There is no further rule.
if there is no further rule, if the members of the legislature elect to make the rule that gave the speaker that draconian power, I will call it a draconian power, to then be able to seize, we all sitting as members of the House of Representatives. They will say, "Oh, speaker, you get it right." Anytime you take time, they seize it. You can seize it. We gave you that right. So they will have to abide by it.
Your Honor, even the agenda is prepared by the speaker.
Now, I mean that,
Even the agenda is prepared by the speaker.
that is. So what we do first, we will have to find a way to abide by the law. The law is to remove the speaker. There must be a section of the House of Legislature, and that section, the issue of the speaker removal must be raised, and the speaker must be accorded due process of law. And I'm not as we have talked about, we are getting to go along with the rules of the House of Representatives, and then we make it our duty to make ourselves go from leader to leader. But the issue that we have now is how can we bring order, stability, and get chaos out of our system of governance? That's what we are more concerned with.
And I'm suggesting to Your Honor that there is no chaos until you call it chaos. Let me continue, Your Honor. There is no chaos until you call it chaos. There is no chaos until the press keeps saying chaos, chaos, chaos. Because there is no chaos. Let me continue, Your Honor.
Councilor Chairman, I wonder what you would term as chaos if you got up one morning and saw your house on fire. You take judicial notice of the fact that all of Liberia woke up in the early hours one morning and the portion of the Capitol building was on fire. That's chaos. Councilor, when we take judicial notice of the court, this court of last resort, take judicial notice that in the morning too, the news everywhere, including foreign news, carrying that people are fighting over a space for the speaker, a car space for speaker, and videotaping it. After that as chaotic. When people are openly emboldened to videotape, citing acts and utterances against the court of this republic, this sacred place, okay, without even having knowledge of the law, I call it chaos. I don't know what you would call it. So don't let the little take it.
Your Honor, please.
And I always say that as chief justice.
You are taking me 5 feet.
Yeah.
I was saying chaos within the House of Representatives. That's what I'm referring to. Because if the House of Representatives were referring to not fire or anything else, because you tell me that before. But what is important, and I left for us to be practical. If the majority never sits with Uncle Koffa, would that house operate? No.
Chairman, that's my problem with your line of arguments. Trying to give relevance and legality, that's the legality to this choice of majority. The law we say, this is the law. Whether a small number or whether a minority, they were joined from day to day and under the presiding officer designated as the speaker until we can find a law on how to bring the members to constitute a quorum. So with this new nomenclature of this majority, I haven't seen it legally in the books, within our jurisprudence when it comes to the legislature. Quorum. And the law says this is how a quorum will be. This is how a quorum will be act. Okay? Mr. Presiding Officer, Mr. Speaker, members of the House of the legislature, you, the legislature, this court says we have to have laws to say how to compel members to go and sit for the business of whichever house. You have not done that law. There is no law. Then you come with this line of argument of majority, and that's what gets me, right out. Where is it? What is the legal thing of this majority?
You got only the majority can get law. Only the majority can get law.
A quorum, Councillor. A quorum.
That's a quorum majority.
There is a difference, Councillor Sherman, between majority and a quorum. There is a distinct difference.
A quorum is what?
I'm pretty telling you, I said there is a difference.
So the members of the house. You have the majority. You have 73. So
Including
37.
the presiding officer.
So 37 will make them a quorum. That's what I'm saying. If not, and then this is Your Honor, I gave deference to you because you are in justice. From my experience as a senator, the vice president is sitting in his office and the president pro tempore resides.
There is a coordination on that. The vice president never got a case here to say that the pro tempore is sitting without him and that he's supposed to have been there at that particular time, but the procedure required when we get that case taken from him.
That's one of the reasons why we attached the opinion of the Minister of Justice, who said if it was the intention of the drafter of the Constitution, that once the Speaker is not there, the House cannot.
Mr. Chairman, there is no Ministry of Justice participation in this proceeding.
Your Honor, he gave an opinion.
Justice
He gave an opinion. Your Honor, are you telling me that in executing the Constitution, the Minister of Justice did not advise the President how to proceed? So I'm just
let it be known. Because sometimes you are shy away and you have to deliberately hide It is the duty under the law, the executive law, for the Minister of Justice to give the precedent and opinion, and it's qualified, it's there for everybody to see opinions of the Attorney General. You go to the Ministry of Justice now, you got a qualification of so many opinions of the Attorney General to the President of the Republic from J.J. Robert down. So you don't have make this here and you sit quietly and the public castigating the court as well, and you are supposed to be educated there. You want to close? You want to be responsible? You want to close? From henceforth, adequate protection for every member of the Supreme Court. You will be closing or will be closing or ask your question.
But Your Honor, please do hold me responsible for how you come across. Let us say anything about what is coming from.
Educating the public to also educating the public.
I'm having a case for you. I'm not educating the public. Because I don't talk to public. I talk to the court.
That's good. But I'm there educating the public.
When we go to the video, people gave all kinds of comments. But we felt that somebody said, oh, I understand the opinion, but the layman, the way of reading, would not understand. So we said, when I'm writing out, apparently when I'm writing for laymen, we're writing for people who would understand the opinion. And we simply say, gentlemen, the Constitution says it might not be clear, let us interpret do this, do that, and go and get together and solve your problems. We don't want to come up here and say we're solving problems for you, because the Constitution and your people see this enterprise. So go now and act as per the rules and as per the Constitution. We left it at that. They wanted us to say you're wrong, you're right, the case is that. But we didn't get that from the opinion. So the clients, we interpreted it and went. That we felt was sufficient for them to go and do what was right as per the law. But we get a bit of information that says, hey, we got a justice minister who interpreted it. And so the majority, they proceed, I guess, as per his interpretation or whatever. Well, a bit of information before us. And let's see how the minister will come interpret our ruling in this right.
Your Honor.
No, I just want to say, to say that, let's think about, just the fact that you mentioned the minister of information. I think it's
He advises the President, the Executive, the Minister of Justice.
yes.
He advises the President on how to execute in your ruling. You do what? You see, I don't know about hearing, I know about the document that he wrote. You see, for me, I don't know about hearing from the grapevine. Please, Your Honor.
Councilor Shema, we want to close now and pray.
Your Honor, this is a democracy. This is a democracy. And in a democracy, it's the majority. Somebody might not want to hear the word majority, but it is the majority. Even among you five here, it is the majority. It is who? The majority. You said you did not recognize the resolution, but it was given to you. Some are 15 members of the House of Representatives. Now, one member is the majority. Is the majority that is the president. But there is a procedure for accreditation, right? It's the majority. But the majority of the people are the satisfied with the
of the 6 members of the House, you say you didn't want to look at it. Did you see the minutes of the investigation? You say you didn't want to look at it. Did you see the
and the procedure they follow, all of those instruments would have been looked at. And the procedure they follow, it is just a procedure that we are more concerned with. Follow the procedure. The majority acting is the power, exercise the power the way and in the form that the law provides. The law says, go down there for the 9 person, move the speaker. That's what the law says. If you delete the speaker, you delete there, but the 9 you go to section, and then you raise the issue, speaker, we have problem with you, we don't want you. So we want to have the hearing based upon that. And then the law provides that you must do the due process. After the due process, then your vote. When you vote, then when you get the 49 vote, the speaker will automatically
we not due process was recorded. Look at our documents and then you can decide how to look due process.
Can I say the majority will agree what it must be done based upon the law. The law provides all the
because when we start, there was a deputy speaker.
That's what the law says the speaker.
When the law also says in the absence of the speaker, the deputy speaker.
The speaker will have absence. That don't say that.
I don't understand why the speaker has been absent when the majority is sitting and the speaker is not there. They say he's present. The majority is sitting, the speaker is not there. They say he's present. He is not present.
The same question I raised with nothing to do. It's the same question. I never went to the detail of this matter. No, when I asked you the last time, I said, I've been you done. My question is, was there a mandate sent to the court below that was violated by any party in the proceeding? Now, whether you coming back, or party coming back to the school?
No, Your Honor. None whatsoever. None whatsoever. The mandate of it that you say was to the House of Representatives.
Go any city you have, must be what? Minimum and simple majority. We are finished. You are finished. Because you refer to 2 parts of the Constitution. You say first, conduct yourself in people will which means any city you have, there must be a quorum. Simple majority. That's number 1. Then Article 49. The president of the House shall elect a speaker, who shall be the presiding officer, a deputy speaker, and other officers. Then it goes on to say, if you want to remove your officer, your speaker, and deputy speaker, you need 2/3 to remove them. Those are the 2 articles of the Constitution which say what you comply. And we are saying there was no sitting where there wasn't a simple majority. We presented governors of the House to you. There was no sitting, there was a simple majority. They have not identified a single sitting that was a simple majority. And we also told you that there was compliance with Article 49 of the Constitution because 50 or members of the House of Representatives signed a resolution to remove the speaker. Now, one signatory has come and said we didn't sign. Now, one signatory ever filed a petition for reconsideration of that decision. We put all of that to you correct. So, what wrong has been done to come back to you?
They signed it, just come in and get it paper and sign it.
It didn't happen that way. We show you the minutes. We attach the minutes. We attach the complete. We attach the journal.
There's a procedure you have for removing, and it's open to the public.
Your Honor, it wasn't in line.
Councilor Sherman, comment 3.
Your Honor, our prayer is
kindly yield to the prayer in your council. Thank you.
You want me to read my prayer to you?
No, just sit it there and the clerk will put it on the minutes that the councillor yield to the prayer contained in his prayer.
Wherefore, and if you are before going, respondents pray your honor to declare one, that respondents have not violated the order or amendment of the honors, opinion, and judgment of 6 December 2024 in the Constitution. And 2, that the amended bill of information is meritless, unfounded, and frivolous, that the prayer of said amended bill of information is denied, and 4, that the entire bill of information is dismissed, reports against the opponents, and appropriate sanctions imposed.
Thank you, Councillor. Informant, please come and pray. Justice Wright, proceed.
Thank you.
And you will pray.
I will receive that.
Yeah.
All right.
Yeah.
Your Honors, I will commence where my big brother left off. The question,
Mr. Marshall, if there is not perfect quorum in this place here, please remove the persons who want to fight here. If they do not want to move, let me know so we can call in the police. Thank you. Proceed, Justice.
thank you. The question was, or is, what violation of the mandate of this court has brought us back to us, brought us back to you? Let me answer.
No, don't answer it like that. The question I want you to answer
Yes.
first, what is the mandate?
Good.
What is the mandate?
You ordered that the House should abide by Article 33 and Article 49. That's the mandate. That's what you ordered them to do. How do they abide by it?
Who order who?
The Supreme Court.
We decide that place where we say we order you, the legislature. We that place in our opinion where we order
You
and
made a declaration.
oh, now you qualify it.
You made a declaration. Yeah, but wait now. That declaration had to go back. The going back is the mandate. Yes.
Okay.
You made a declaration.
Okay.
You said any action.
Carlos,
Yes, Your Honor.
in a declaratory action,
Yes, Your Honor.
the police has to declare rights. Right, this no?
Yes, Your Honor.
When you declare rights,
Yes.
the parties are expected to govern and say accordingly.
Thank you.
But the court does not give order to say go this right and declare go and live by it.
Your
You
Honor.
want to do that?
I
If
agree with
you don't
you.
get money, they will say go and do X, Y, Z. Go and declare right. This is the right. This is the right.
It is to go and do the experts here that have brought back because they have not done it.
But the way you
I have not done it.
the way identify the X, Y, Z.
Your Honor, you said any action done or taken in violation of Article 33 is ultra-violent. It's illegal.
In my mind,
thing that has happened since December 6th is also ultra-viral. They have disobeyed.
So, kind of, in other words, this book did not answer the question of birthday. That provides solution to the question of birthday, right?
Say that again.
This book did not provide the issue, did not provide solution to the issue of birthday.
Your Honor, in my opinion, this court spoke in English. This court spoke in English. Who can understand English?
That English in my interpretation is minority, you cannot proceed.
Thank you.
Majority, you cannot proceed without the speaker, right?
No, A and B. Majority, you cannot proceed without a quorum, and you also cannot proceed if the speaker does not preside. That's the violation by the majority.
I'm saying that.
Yes.
So that left the executive and the legislative open, right?
Yes.
No, that majority, right?
Your job,
So my question to you now, how do we as a government put our function?
Your Honor, the function of this court is to make declarations. Declare what is right and what is wrong.
And the reason that we proceed that we like this country.
When you do that, Your Honor, once this court has made the declaration, if I say bring it back, come back and put it in jail, to grab it out of there and throw this person and put it up right now, that's your control. Enforcement of your decisions is not executive branch of government. In this case, this court said, let the House of Representatives abide by Article 43 and 49. Conduct yourself according to what the law is. That's what the court said. And we have come to say to you, they have not conducted themselves according to Article 39 and 33. They have not. For example, since December 6th, the acts that are authorized, number one, they claim to have passed the budget. That's one violation. Two, they remove. Yes, Your Honor.
I think it is a good time for you to pray.
I didn't say anything, someone pray. Your Honor, I will obey the orders of the court. I will obey the orders of the court. But I think you should me.
Counselor, all the things that you're reading, they are before us, in black and white.
Thank you.
So pray.
All right, let me pray.
You see how I can switch from public justice to counselor?
That is it.
No, I'm listening to you.
That is it.
You were coming and said pray. You said if, then I said no justice, proceed. But now I say counselor, pray.
Okay, I will pray, Your Honor. The informants respectfully pray, Your Honors. To the land.
So maybe you're brief, please.
Someone read it, we are talking. He read it.
But read your book. But you are ready to do it. Read your
I'm ready, imagine you. Why did I read it before you?
I'm going to go to the people read it. You're right.
All right,
Counselor, please yield to the prayer in your brief. Okay. Otherwise, I've been spent on this.
all right, the informants yield and submit to the prayer contained in their brief and respectfully submit.
Really reserved matters suspended. Mr. Clerk, call case number 5.
So folks, thank you so much. We just listened to lawyers representing both the majority bloc and the minority bloc here in the Supreme Court of Liberia. And both sides argue the bill of information filed by former House Speaker
This is not a this
Councillor
session,
Fulanti Koffa,
we are still in
and
session
Chief
here.
Justice
We
Saneyo,
call
along
another
with the
case.
4 associate justices,
Go ahead and call
have
case number
reserved
5.
rulings into the building information to be announced in subsequent time. So folks, thank you so much for following LNTV and Iram Talo. But this live happening. If I've been here, I've also been here. We both have been here, bringing you this live happening. Thank you so much.